Frank Taney. He's going to speak to some legal and intellectual property issues, and I encourage everyone to ask questions because Frank's services are probably quite expensive, and you might get a chance to ask someone like him questions of interest to you, except in a forum like this. So, go ahead. Thank you, Frank.
I'll say I'm a bargain in any price. But good afternoon, and I am just one of the best parts of my job is I get to see what everybody else does for a living. Represent all kinds of people in all kinds of industries. They certainly have a focus on information technology and within that emerging areas of information technology. And this is to sit here throughout the day and see the breadth and depth of the expertise we have assembled here. Just go to a lot of conferences. This is one of the best I've seen, and just kind of in a very DIY way we just put this together. So it's outstanding. A minute or two on my background just so you can see what experience informs what I'm going to talk to you about. I started out and remain a trial lawyer and commercial litigator, and over the years I've focused on a number of substantive legal areas, one of which is information technology. Over the years I also developed a practice, a licensing practice, heavily focused on intellectual property issues, and transactional practice, helping a lot of businesses in the information technology industry or those procuring services and products from companies in the information technology industry navigate that procurement process, navigate the project management process, for example, the development and implementation of custom software, all those things. So I've litigated these cases, faced the jury, sat down with people starting businesses out of their garage or living room, saying, what template contracts do you need in place to help you do business safely, make money day in and day out. So that is the perspective I have and the experience I have with it. And closer to home here with the subject matter, as I briefly alluded to at the start, I have some substantial practice representing people involved in virtual world technologies. Most of it's been Second Life, but some people involved with Sun Wonderland, OpenSim, and some of the other open source projects. I'm on the council too, and on the board of something called the Open Metaverse Foundation, which is developing some open source versions of the Second Life viewer and other things. So so that's sort of my transactional practice and counseling practice. I also litigate for clients of all sizes within virtual worlds, and as I said, I had two, just by dumb luck, I suppose, very well publicized cases. A client who sold virtual adult themed merchandise called Eros LLC, and he was getting ripped off in the world, and so we brought two federal lawsuits alleging trademark and copyright infringement, and those were the first two of their kind. So we're a lot of exposure. And what that taught me was that the law does not develop in leaps and bounds. The law sort of oozes. It creeps along, especially when it contacts new technologies, new and emerging technologies. So what we lawyers do in dealing with a new situation or trying to tell a judge who should win or lose if you're dealing with some technology that nobody in the courtroom's heard about is you say, okay, this is really like X, right? And so there is not a lot of case law on chatbots. There is a developing body of law, case law on bots. And I see what you guys want to do with bots and or chatbots, and I would say to you that the law is agnostic towards bots. It is use it as an application with many potential beneficial applications, of which we've heard all day long, and we will hear after I sit down, and many potential malicious applications. Not so much in the areas that you guys are working, but in other areas I'll just briefly touch upon. And with my half hour or 20 minutes or whatever it takes, I just want to talk about some areas of potential legal exposure to you botmasters and people trying to advance this technology so that you don't unnecessarily get in the suit. So, what we've seen, what the courts have had to deal with, and what the legislatures and bodies like the Federal Trade Commission in this country are dealing with are misuses of bots. Maybe I should get out a little bit, guys. Using bots, so a bot just being, as the law looks at it, an item of software that allows tasks to be done in an automated manner and to serve as a surrogate for a human being and in many cases to perform a task in a routinized way, in a mechanical way that a human could not do, or at least you need a bunch of bodies to throw at it to duplicate it. So we see bots that crawl the web and try to harvest emails for spam. There's a well-publicized case of Blizzard, the outfit that runs World of Warcraft, sued a company that made this bot called the Glider Bot, and the Glider Bot was designed to enable a player to do tasks. And I'm not a World of Warcraft guy, but I know enough to know that you earn gold or whatever it is, and this would allow you to work at this 24/7 and increase your stature and progress through the levels of the game. And this was altering the competitive balance of the game, and contrary to what Blizzard wanted. So that was a well-publicized lawsuit I'll talk about. Website scraping, to the extent that they're taking proprietary information off websites or information that is meant to be restricted access. Bots are sometimes used to do that. Unfortunately, sometimes they're used to deliver viruses and other malware. They're used to launch denial of service attacks. Ticket sniping refers to bots that go, your Ticketmaster.com or your concert websites that have a queue function, or the way it's supposed to work, and these programs that come in and snatch up all the tickets. The next Bruce Springsteen concert, the minute after it goes online, all of a sudden some mysterious company has all the tickets. There are a host of other instances we've seen where bots are used to gain or give its user, its deployer, some kind of advantage. I say unfair, that's a pejorative term, but some kind of advantage over other users not using bots, and depending on the perspective of the person who's hosting the website or offering the website, that may be unfair and that may be contrary to the spirit of what they're trying to accomplish. I mentioned spam, and there are others, as infinite number of fact patterns. So where, as someone, a lot of you in this room are, you develop bots, you are offering them for license and for use. You may be looking to, in other words, you are licensing them to third parties who you know or should know are going to be doing something with them. They're going to be deploying them. They're going to be executing them out there in the world and affecting third parties. And you don't know exactly all the things they're going to do, but you know they're going to do them. You may also have bots that you intend to directly deploy yourself. Just a first-person actor that a bot is designed to be, for example, deployed in Second Life to do something, or a bot is designed to be deployed in some social networking site to market or hustle people for business or something like that. So there are those are the two states of being. You're either licensing it to someone who's going to do something, or you're doing it yourself.